Requests for admissions. Requests for admissions are one type of discovery that can often be overlooked, but it's very important to understand and use effectively. Generally speaking, requests for admissions are a series of statements such as, were you at the accident? Were you involved in the accident? Did you cause the accident? A lot of them can be very simple, and the purpose for them under the Texas Rules of Civil Procedure are to narrow down basically what's being fought over. And that's good for everybody involved. It means less attorney's fees. It means less time spent trying to figure out and attack meaningless or unimportant parts of the case. Now, as a practical matter, a lot of times they're somewhat abused. The first thing you have to realize with requests for admission is if you receive them and you do not answer them within 30 days, then they're what's called deemed admitted. That means that your opponent can basically file anything, whether it be summary judgment or anything like that, with the court saying that the answers that the other side gave were that they admitted all of these things. And generally speaking, in your request for admission, there's going to be a number of things such as, are you responsible? Did you steal from your client? Did you do this wrong? Did you do that wrong? And so it's very important to answer them in time. Now, judges are generally speaking very reluctant to end a case on the basis of unanswered requests for admission. If you are late answering a request for admission, and you never should be late, but if you are late, you should file something called a leave of court to answer late admissions. There's legal standards on what constitutes good cause for missing the deadline. It's kind of an odd term, good cause. I don't know if there's ever good cause to miss a deadline, but if you do, there's very specific legal standards you have to meet, and generally speaking, it's not difficult to meet them. I guess that's a reflection of the fact that the appeals courts are fairly reluctant to determine an entire case based on this. That said, it's important to file the right things, because on appeal, if and when it gets there, if you haven't filed the leave of court to undeem the admissions, you're going to be potentially in a lot of trouble. The other thing you have to watch out for whenever the other side is answering your request for admissions is, and you actually see this a lot, where they just deny everything. Just deny, deny, deny. Deny that you're admit or deny that you're a person. Deny. Admit or deny that you know the defendant. Deny. And a lot of times, an attorney can get away with this, or a party can get away with this, but it's very important, in my view, from the start, if you encounter this sort of situation, to call it to the attention of the court, file what's called a motion to compel, which can be used in a variety of circumstances. But in the context of a request for admission, generally speaking, the issue is they're just denying everything. Generally speaking, you're not going to get attorney's fees for it. What most courts are going to do is just say, you've got to take a better look, you've got to answer them. If and when they do, they're still probably not going to answer them as fully as they should, but at the very least, you're not setting a precedent where you're just going to let everything slide, which I think is tremendously, tremendously bad. There are actually provisions in the Texas Rules of Civil Procedure that will allow you to get attorney's fees if your opponent doesn't follow the proper procedure, specifically make some sort of a reasonable effort to answer them properly. Whenever I receive requests for admission, I think the best policy is just to answer them. Of all the different kinds of discovery, it's one of the easier kinds to answer. Either admit it or deny it. If you're too lazy to give a good, solid answer on that, you're sending a pretty clear signal to your opposing counsel that you're not taking the case very seriously. And my view is, if you're not taking a case seriously enough that you can answer requests for admissions, which are probably the easiest kinds of discovery to answer, then you really have no business taking that case, and you should leave it for another attorney that might care enough to answer them properly.